rescission. Rescission is a common law and equity remedy. These provisions allows one party to ask the court to strike aside the agreement and return the parties to their pre-transaction positions in equity. Rescission can be done by the parties, although the court often helps them reclaim property. Contractual force persists until revoked. Also called Rescission in integram, Chapter 4 of the Specific Relief Act 1950, known as SRA 1950, describes rescission in sections 34 until 37. Okay, first, equity can break a contract where the common law cannot. Equity has a more flexible interpretation of rescission in integram and can be enforced necessities like an allowance for facilities or an order for accounts and inquiries. In the case of Buckland against Farmer and Moody, requires content to determine the definition of rescission. The third is that equity can offer relief in the applicant performs equities. Next, we move to the nature of rescissions. Unlike particular performance, rescissions allow the parties seeking relief to terminate all contract obligations and treat the deal as never having been executed. If parties cannot return to their initial positions, revocation is impossible. Damages are not recoverable in rescissions unless fraudulent misrepresentation occurs. In the event of rescission, it is generally impermissible to seek the additional damages, as in the case of Redgrave against 1881. With respect to the defendant's counterclaim, we hold that it is unsuccessful in terms of damages. This is due to the fact that he has not provided evidence of the plaintiff being aware that the claims made by the plaintiff were false, nor has he elaborated on the allegations sufficiently to establish a claim for deceit. Rescission occurs when a party stops executing the contract and deems it void from the start. Unlawfully abstaining from contractual obligations may constitute a breach of contract. Hence, the party breaching would usually need a court order to officially terminate the contract.
Rescission is a type of equitable remedy in equity that the court determines and applies. The court have the authority to decide whether to provide rescission, and if they do, what kinds and how much of that relief they will grant. If an equitable mitigating reason is found and none of the rescission's bar supplied, it is nevertheless accurate to describe the claimant as having a right to rescissions, because the discretion is used in accordance with the statute principle. In requesting the court to void a contract, the claimant may do so explicitly or implicitly, as in the case of an application to start a process to retrieve property from the defendant. Nevertheless, there are few consequences on the grounds of rescissions. First of all, we have terminations of the contract. Next, we have prevent unjust enrichment. Other than that, we have compositions. And last but not least is apportionment of loss. So we're going to go through with the first consequence, which is terminations of a contract. So the contract is basically regarded as never exist. Therefore, even though they should have been fulfilled earlier, any upcoming contractual duties are discharged. And other equitable remedies like specific performance and injunction will also no longer be available. As the contract be deemed to have never been, the obligation to pay damages will also be nullified. Next, the second consequence is to prevent unjust enrichment. The parties return to their pre-contractual position is one of the essential effects of rescissions. As a result, the claimant will have to repay the defendant for any advantage they may have gained as a result of the transaction, and the defendant will have to reimburse the claimant for any benefit they may have obtained. The advantage method could be cash, product, or service. A separate claim in just enrichment will not need to be brought. The next consequence we have is compensations. If one party has lost something in the course of carrying out the contract, the other party will have to make up for that loss, since it is necessary to get back to the parties to where they were before the deal. Reimbursement for repairs or improvements made to the property acquired in the contract is available to the claimant, should the claimant be mandated by the contract to carry out these repairs or enhancements. Last but not least, the last consequence is apportionment of loss. Rescission typically results in a requirement for one party to reimburse the other for gains. Nevertheless, there are situations in which a contract has caused a loss, in which case the court may attempt to divide the loss between the parties. This was further illustrated in the Cheese versus Thomas case, where the court imposed the conditions on rescission, namely that the loss be divided equally between the parties in proportion that they are deemed to have entered into a joint bond shares, and as such share the loss between them.
Myself, PRAVEEN, will be explaining on misrepresentation and undue influence as grounds for rescission granted by the court. In brief, the aim of rescission is as a remedy to restore the parties to the pre-contractual situation and release them from the contractual obligations and duties. Types of rescission are rescission for breach and rescission ab initio. But let's delve deep into the rescission ab initio. Section 34 Clause 1 Clause A of the Specific Relief Act 1950 stated that rescission may be adjudged if the contract is voidable. The first type of contract that is voidable is made with misrepresentation. It refers to a false statement of fact made by one of the party to induce the other party of the contract to enter and sign the contract, and in detail it was explained in Section 18 of the Contracts Act 1950. Three types of misrepresentations are innocent misrepresentation, where the innocent party is entitled to claim for rescission, and negligent and fraudulent misrepresentation, where rescission and additional damages could be granted or entitled to the innocent party. Second type of grounds where the court may give rescission as a remedy is due to undue influence. A contract is classified to be induced or affected by the undue influence if there is already an existing relationship between the parties contracting, and there's one of the party who is in the dominant position takes the unfair advantage of the other one, as stated in Section 16 Clause 1 of the Contracts Act 1950. In the case of Tengku Abdullah Ibn Sultan Abu Bakar, it was held that due to undue influence based on a fiduciary relationship between the parties, usually the party or the innocent party may relieve himself for rescission.
Assalamualaikum and welcome everyone for today's forum. Today we'll be talking about two interesting cases about rescission in law of equity. The first cases is about Fabulous Rescission against Halina, daughter of K. Karamutu, and the second cases is about ZUHAIRI bin Zainal Abidin against Julia binti Muhammad Hassan. Alright. Be joining us today is two outstanding panelists, which are Miss MAISARAH and Miss YASMIN, as the two panelists that will be discussing about our topic today. Let's start the discussion with the Fabulous Rage and Helena cases first. This case center about property purchase agreement with alleged with defect and misstatement. Okay, the Court of Appeal, as we know, ultimately denied the Miss Helena claim for rescission. So, panel 1, could you explain the key point of the court reasoning for their decision?
Thank you to our Mr. Moderator. Before I point out the key points of the court reasoning, let me explain a bit about rescission. Rescission typically involves circumstances that justify cancelling or avoiding a contract. Common grounds may include fraud, misrepresentation, undue influence, mistake, or a breach, a material breach of contract by one of the parties. Okay, back to the cases. Certainly, the court found that even though defects were present, they were not severe enough to render the property uninhabitable. Additional, Miss Helena had taken possession and exercised right under the agreement and continue paying the loan, implying an affirmation of the contract. This really weakens her claim for rescission based on the total failure of consideration.
Thank you, Miss Yasmin. Alright, panel 2, in ZUHAIRI bin Zainal Abidin and Julia cases, we saw a claim for rescission due to alleged undue influence on an adulterous woman with Alzheimer. So, what were the key factors in the court decision for that cases?
Thank you, Mr. Moderator. So, in this case, the court considers several factors, and based on the provided factors of one has now lack of mental capacity, undue influence, and inconsistent evidence, it can be concluded that the compelling case could be made for her to successfully contest the case.
Thanks for the detailed explanation. Now, let's open for the question from the audience.
I have a question. So in Fabulous Range case, could Miss Helena pursue the damages instead of rescission?
Thank you for the question. Yes, that's a valid point. If she could prove the defect caused a significant damage or inconvenience, she might have entitled to monetary compensation for breach of contract or warranty instead of rescission.
Sorry for interrupting respected panelists. I have a question towards the second panelist. In the case of ZUHAIRI, could the assignment still be valid if Miss Julia had the lucid moments?
Thank you for the question. So the burden of proof falls on the party claiming the validity. In this case, the evidence demonstrated a consistent lack of capacity, making it difficult to prove lucid moments sufficient for understanding the document.
This has been a fascinating discussion that we had. I'd like to thank our panelists for their insightful contribution and the audience itself for the active participation. We hope this forum has shed light on this complex legal issue and protection of the vulnerable individuals that involved in this case. Alright, to summarize all of our forum today, a rescission significantly affects all the parties and can comprehensive. Breaching a contract means that any future right and responsibility resulting from it are terminated and handled as if they never had happened at the first place. Thus, all things that had received during the contract, like money, goods and even services, need to be returned back to the owner. Thus, it will give a huge impact towards the innocent party and make their life more easier in the future. Thank you for lending us and have a great day, everyone. Bye. Thank you.